If you've been injured in a car accident in Kentucky or Indiana, you're probably wondering, what is your case actually worth? And here's the problem. The insurance company's first offer usually is a fraction of what you deserve. In this video, I'll break down exactly how car accident settlements are calculated in Kentucky and Indiana, and what factors can compromise your compensation, and why knowing your case's true value is the key to not leaving thousands of dollars on the table. Hi, I'm Carl Truman. As a retired United States Army officer and attorney for over 34 years, I've helped thousands of people across Kentucky and Indiana with fair compensation after serious injuries. If you or someone you love has been hurt, don't face the insurance companies alone. Call 2222 and count on the Colonel. Let's start with the most important thing you need to understand. There is no magic formula or calculator that spits out exactly what your case is worth. Every case is different. But there are specific categories of damages that Kentucky and Indiana law allows you to recover, and understanding these categories is how we determine the true value of your case. The two main categories of damages. In Kentucky and Indiana, car accident damages fall into two main categories: economic damages and non-economic damages. Economic damages are the monetary losses you can calculate with a receipt or bill. These are concrete, provable expenses. Non-economic damages are intangible losses, things like pain, suffering, and how the accident has impacted your quality of life. These are harder to quantify, but they're often the largest part of your settlement. Let me break down each category so you understand what you're entitled to recover. Economic damages, your measurable financial loss. First, let's talk about medical expenses. This is usually the easiest category to calculate because you have bills and records. Your economic damages include all the past medical treatment like emergency room visits, hospital stays, surgeries, doctor's appointments, diagnostic tests like x-rays, MRIs, and CT scans, physical therapy, chiropractic care, prescription medications, and medical equipment like braces, crutches, or wheelchairs. But here's what most people miss. You can also recover future medical expenses. If your doctor says you're going to need ongoing treatment, future surgeries, or long-term care, that gets factored into your settlement. The insurance company doesn't want you to know this because they'd rather settle before you understand the full scope of your future needs. Next, you have lost wages. If you missed work because of your injuries, you're entitled to compensation for that lost income. This includes hourly wages, salary, commissions, bonuses, and even sick days and vacation days you had to use because of the accident. You'll need documentation like pay stubs, a letter from your employer, tax returns to prove your income and the time you missed. And just like with medical expenses, you can also recover lost earning capacity. So if your injuries prevent you from returning to your old job or limit your ability to earn income into the future, that's compensable. Maybe you were a construction worker and now you can't do physical labor. Maybe you were a nurse and can't lift patients anymore. That lost future income is real damage, and it should be part of your settlement. You're also entitled to recover property damage, like the cost to repair or replace your vehicle. In Kentucky and Indiana, if your car is totaled, you're entitled to fair market value of the vehicle just before the accident, not what you paid for it years ago. You can also recover the cost of a rental car while yours is being repaired or replaced. Any personal property that was damaged in the crash, like a laptop or a phone or other belongings, are also compensable. There are also other out-of-pocket expenses that can add up, such as towing and storage fees, transportation costs to medical appointments, household services if you had to hire someone to clean your house or mow your lawn or take care of tasks that you couldn't do and can't do because of your injuries. Keep every receipt because all of this is compensable. Non-economic damages, your pain, suffering, and loss of quality of life. Now let's talk about non-economic damages. Were often the most valuable part of your case, but also the most misunderstood. Pain and suffering is the big one. This compensates you for the physical pain you've endured and will continue to endure because of your injuries. A broken bone hurts. Surgery hurts, physical therapy hurts, chronic pain from a back injury or nerve damage affects every aspect of your life. Kentucky and Indiana law recognizes that this pain has value and you deserve to be compensated for it. Then there's emotional distress. Car accidents are traumatic. Many people develop anxiety, depression, PTSD, and fear of driving. If you've had to seek counseling or therapy to deal with the psychological impact, that's part of your damages as well. Even if you haven't sought treatment, the emotional toll is real and compensable. Loss of enjoyment of life is another critical factor. If your injuries prevent you from doing the things you used to love, like playing with your kids, exercising, hobbies, social activities, that's a real loss. Maybe you used to go hiking every weekend, and now you can't. Maybe you can't pick up your grandchildren anymore. These losses have value. If you're married, your spouse may also have a claim for loss of consortium. This compensates for the loss of consent, companionship, affection, and support caused by your injuries. It recognizes that your injuries don't just affect you, they also affect your relationship and your family, factors that increase the value of your case. Now that you understand the categories of damages, let's talk about what makes some cases worth more than others. The severity of your injuries is the single biggest factor. A minor soft tissue injury might be worth a few $1,000s. A traumatic brain injury, spinal cord injury, or permanent disability can be worth hundreds of thousands or even millions. The more severe and long-lasting your injuries, the higher your damages. Clear liability matters. If the other driver ran a red light, was texting, or was drunk, and there's strong evidence of their fault, your case is worth more because it's easier to prove. When liability is disputed, the insurance company has leverage to push for a lower settlement. The amount of insurance coverage available also affects what you can recover. In Kentucky and Indiana, drivers are required to carry minimum liability insurance of $25,000 per person and $50,000 per accident. If your damages exceed the at-fault driver's policy limit, you may be limited to recovering what their insurance coverage is unless you have underinsured motorist coverage on your own policy, which can fill the gap. How well you followed medical advice impacts the value of your case. If you went to all your appointments, followed all your treatment plan, did what your doctors told you to do, your case is stronger. If you missed appointments or stopped treating early, the insurance company will argue your injuries weren't as severe and try to reduce your settlement. Your credibility and consistency matter too. If your story has changed, if you've posted on social media doing activities that contradict with your claims, or there are inconsistencies in your medical records, the insurance company will use that to devalue your case. Consistency and honesty strengthen your case. Whether you have an attorney makes a huge difference. People with attorneys recover significantly more than those who represent themselves, even after attorney's fees. Why? Because we know how to properly value cases. We know what evidence to gather, and we know how to negotiate with the insurance companies who are trained to take advantage of unrepresented people. The truth about insurance company tactics. Here's what the insurance company doesn't want you to know. They have a number in mind that they're willing to pay, and it's almost always higher than their first offer. Their job is to settle your case for as little as possible, and they'll use every tactic to undervalue your claim. They'll call you right after the accident when you're vulnerable and offer you a quick settlement before you even know the full extent of your injuries. They'll pressure you to give a recorded statement and ask leading questions designed to get you to minimize your injuries or admit fault. They'll delay your claim, hoping you'll get frustrated and accept whatever they offer. They'll argue that your injuries were pre-existing or that you exaggerated your pain. This is why having an experienced attorney matters. We know these tactics. We know how to counter them, and we know how to build a case that forces the insurance company to pay what you actually deserve. One final thing you need to know. In both Indiana and Kentucky, there are time deadlines that you have to file a claim. If you wait too long, you lose your right to compensation entirely. The insurance company knows this, and they'll drag things out hoping you'll miss the deadline. Don't let the time run out on your case. The sooner you get a professional help, the better. If you've been injured in a car accident in Kentucky or Indiana, call me at 502-222-2222 for a free consultation. Don't trust the insurance company's first offer. We'll review your case, calculate the true value of your damages, and fight to get you every dollar you deserve. Remember, you can count on the Colonel. And if you're dealing with insurance adjusters right now, you need to watch my next video where I reveal exactly what to say and what not to say to insurance adjusters after a crash, because one wrong word can destroy your case.